One of the problems with regard to enforceability of covenant is not identifying the land that's burdened by the covenant, but identifying the land that has the benefit of the covenant. Negligence claims can arise because when you're drafting a restrictive covenant, you don't think about identifying the land that benefits from the covenant. And of course, that's the important point. Just simply identifying the land that burdens by the covenant is half the message. So, okay, no one's answered my question then about this idea about how you deal with covenants in a report on title. But as I say, I think if you're just simply saying there are covenants on the title, I would say in most circumstances, I have not investigated their enforceability, nor have I identified who can in fact enforce them, if anybody can. I think that's the best way of leaving it. I wouldn't buy out a covenant. I wouldn't negotiate a covenant. I wouldn't investigate enforceability of a covenant. What I'm likely to do is either take out an indemnity policy or instructing a property litigator or barrister to assist me with regard to enforceability. The problem with undertaking research concerning enforceability of restrictive covenants is that in carrying out that investigative work, you could well be disclosing the existence of the issue or the existence of a potential policy, which could theoretically invalidate the policy. The next thing I want to talk about is due diligence in resi conveyancing, and to talk about searches and just what due diligence involves. First of all, of course, all practitioners are aware that the client must be advised of the benefit of survey. The client should be told the types of survey that are available, and the client should be told about what you're doing if a client obtains a survey and that survey crosses your desk. You cannot say to a client, I won't be reading a survey or valuation that crosses my desk or that's handed to me. You are obliged to check a survey or valuation to see if there are any issues associated with title or due diligence that the surveyor or valuer generates. I don't think it's necessary to provide the client with a sort of an essay on types of survey or types of valuation, but nonetheless, you should be recommending that a survey is obtained and to explain why, the sort of basic caveat emptor principle. Next issue concerns client inspection. You will all, I'm confident, advise all clients of the importance of inspecting target property. Do you tell your client why inspection is important? Do you tell your clients that they're bound by anything they actually see or become aware of or is revealed to them? And that they're also bound by anything that they ought to have seen had a reasonable inspection of the property taken place. The concept of constructive notice is the point that I'm sort of alluding to there. So clients need to understand the importance of inspection, what they should be doing when they inspect, what they should be looking for, and the fact that they should be reporting back to you anything that they see having inspected. So again, can I ask the room, Lynn, Aidan, anybody else? You're all going to advise the client that they need to inspect. Do you tell them why they're inspecting? And do you tell them the importance of reporting back to you anything of significance or consequence that they see when they inspect? I think the other thing that I would do there is I would, in my report, say I've recommended that you inspect the property. You tell me that you have inspected, and you tell me that there was nothing of concern during that inspection. I think that's probably a safe way of dealing with it. Here's a question, would you attend a residential property on your client's behalf? Philip, if you could answer that one, or Eamon, would you inspect a resi property on your client's behalf? Interesting point. If you did, you should be telling the client why you're inspecting it. I think I've mentioned to you in the past this importance of scoping the retainer. So at the start of the transaction, you're going to tell a client what you're going to do and not going to do. Wherever you do something that you said you weren't going to do in the retainer, you've got to expand the retainer. Yeah, Philip, I'm glad you wouldn't attend. No, your insurers wouldn't be happy if you did, to be honest. Okay. Commercial transaction different, Philip, but resi, not necessary. However, if there was an issue with regard to a boundary or a potential problem, the client said, can you have a look? Or the only way you can make sense of the issue or potential issue is by inspecting. You need to say to the client, in my retainer, I said I wouldn't be inspecting target property. I am now inspecting the property for this particular purpose. In doing that, you're protecting yourself. What insurers are terrified about is a situation where you've said you're not going to do something and then you do it. In those circumstances, you leave yourself vulnerable to claims. And the other point, I think, Philip, is that if you are going to inspect, would you charge the client for the time and energy you spend in inspecting? Again, generally speaking, with regard to fixed fees, quotations or estimates, we're obliged to adhere to the estimate, etc. Yeah, you couldn't charge, Philip, I get that. But you can revise your fees upwards if you do additional work. As Philip's saying, I'm going to be lucky if I'm going to get a client that's going to pay more. What I would do in that situation, Philip, is say to the client, I'm not charging you. I'm doing additional work, but I'm not charging you for it. At least then you're hopefully generating a bit of goodwill. And the other thing you're doing, you explain to the client that, this is out of the ordinary. I'm doing more for you than I would normally expect. So yeah, I get the point that you make about you can't really justify charging more. Fees are a problem. All the webinars and all the forums that we do throughout Great Britain, really, United Kingdom, everyone's the same, really. We're doing more work, but boy, we can't get more fees for it. Unfortunately, so we're all getting more and more work. We're more and more stressed. We're under more and more pressure, more and more vulnerable to claims as well, but not getting paid any more for it. Just as an aside, does anyone in Northern Ireland advise clients of the availability of climate change reports? Just changing tack completely and going off piste, not on our list of topics today, but I'm just thinking about this. Climate change and climate change reports, anybody? Philip's typing something. Michael? Anybody else? Sean? Flood is a big issue. I tell you what, Philip, there's a really interesting article in today's Estates Gazette on the law relating to flooding. What I'm going to do, I think, is do a little paper on it, do a little article relating to it. But there's a paper written by a KC in the Estates Gazette. It was quite an interesting point. The reason I mention that is the Law Society of England and Wales is due to report for conveyancers about what they need to do relating to climate change. Currently in England and Wales, conveyancers are told that they should make clients aware of the existence of a climate change report. And most firms are doing that. The concern that most conveyancers have is that they're going to be asked to advise on climate change. Well, the Law Society's guidance for conveyancers that's coming out in January is saying, no, you're not required to do that. So, Sean, you don't. Okay, well, fair enough. To be honest, when you look at climate change reports, you think to yourself, well, all right, yeah, global warming is happening, but how can you say with any certainty what's going to happen 10, 15, 50 years' time? So I'm not a massive sort of fan of climate change reports. I am worried about conveyancers being told that you should be asking clients if they want them, or there's some sort of misguided information going out that you're negligent if you fail to advise the client about the benefit of a climate change report. I don't think that's right at all. Some good news related to that. Going back to Philip and flooding being a big issue, yeah, massive issue. Again, as far as flooding is concerned, drainage and water search, Philip, and seeing what the seller has to say with regard to history concerning the property that they're selling. But flooding is a massive issue, isn't it? And again, as I say, if anyone's interested in that work I'm doing with regard to flooding and looking at this case law point, drop me a note and I'll get back to you. So yeah, Philip, so you can obtain a floodplain map. You wouldn't get advice from an expert, though, with regard to flooding. You wouldn't get an opinion, etc. You just get a map and map that against the site or the location of your client's property. Yeah, okay. A lot of environmental searches in England and Wales now include climate change. Don't know whether that's the same in Northern Ireland. With regard to environmental searches, again going slightly off piste, be careful. An environmental search will give you historical land use, but won't necessarily give you a risk assessment with regard to contamination. So sometimes it's worth getting an environmental search and report. And it's also wise to report to clients where there's an old historical environmental search and report that could be out of date, and it may be appropriate that a new report is commissioned by your client rather than relying on anyone else. Yeah, they do. Philip, thanks for that. Yeah, I've got that point. Okay, right. Let's change the tack. Who's read the Law Society Supervisor's report on money laundering? Thrilling bedtime reading, I have to say, but who's read it? Very interesting, to be honest. Very interesting indeed. I just want to go through it with you if I can. Yeah, Philip, again, I quite understand. Hey, we haven't got time to do our day-to-day work. That's why, that's how I make my living. You ladies and gentlemen, don't have the time to go sort of studying some of this stuff, and I quite appreciate it. I just want to take you through some of the highlights or lowlights, depending on how you look at it. So the first thing that we've got in this, if I just pull it up again on my screen, yeah. Yeah, well, I agree with that, Philip. Yeah, you're acting as police force, MI5, and all that goes with it, aren't you? Crazy. Let's just have a look at it. Client and matter risk assessments undertaken and evidenced on file and reviewed throughout the life of the transaction. Do we do that? Just checking. No, well, we're required to, Philip, unfortunately. Sean? One of the things I say to people is, if you will have risk assessments, yeah? You'll have documentation and checklists that you use, or case management systems, yeah? But what I suggest you do is, well, there's two things I suggest you do. One, if you can, keep data as to the types of client, the types of work that you're doing, right? Review the data, let's say annually. I would say if you can, do it quarterly, right? And let's assume the data reveals that the vast majority of your conveyancing work is for clients that are local to you and clients that come into your office to sign documents, to verify ID and all the bit, yeah? And then all of a sudden, Q4, 2024, you're getting clients from all over the place. Buy-to-let investors from the UK, international clients from France, wherever it may be, right? So your client profile is changing. There'd be an expectation, A, that you've got data to show that, and that you then review your policies. So, at the moment, all you're doing is work in the locality of your offices. Your clients have to come in to see you to verify ID. You won't act for anyone that doesn't. And then all of a sudden you change, okay? If you change, you've got to show that your policies change. Now, it may be that your data is simply showing that you're acting for the same sorts of clients that you've always acted for. Well, in that case, all you're doing is saying you've reviewed data, existing client intake is similar to previous year's intake, therefore no need to change. Yeah, it will, Sean. We'll make sure that's taken care of, and thanks, and no problem, Sean. If you want any topics for next time, let me know, and we'll incorporate them and deal with them. Okay, happy to do that. Okay, right. So let's just carry on then with this stuff because it's interesting. Right. Client identification evidence on file or a central register. Again, kept up to date. Firms' policies, controls and procedures, including source of funds, source of wealth questionnaires, checklists, completed and retained on case files, together with documentary evidence and support. Well, do we do that? So do we have our policies and procedures? And do we ensure that our files, our case management system, reveals application of those processes and procedures? I tell you what's happening. If you're subject to an inspection, not only will whoever's head of conveyancing be asked to produce policies and procedures, the file or the online documentation, but they may well interview fee earners and say, right, your money laundering policy, your sources of wealth policy is X or Y, or they may even say, tell me what it is, and then show me your file and show me how you've applied it in this particular transaction. Okay? So it's not just a case of having policies and procedures. It's not just a case of reviewing them, but it's a case of applying them and making sure staff are trained. Interesting point, Philip. If you had a locum who came in to assist, during the holiday period, or if you had staff that was off ill, Are they familiar with your procedures and processes? Do you sort of, when they come in, give them a review or show them policies and procedures and show checks and balances that are undertaken with regard to files, etc.? Again, important and something that will be looked at. Okay, going on from that then, let's have a look at what else. Assessing client matters and assessing risk with regard to client matters, showing an assessment as to whether clients' financial circumstances, business activities, sources of funds, and source of wealth and source of funds align with the background and wider profile of the client. This touches on a point that again is so important. Do you know your client? So, all right, how many firms that we're talking to today will actually sit down and see clients? How many, where they're dealing with clients at a distance, will have virtual meetings, the dreaded Zoom or Teams meeting? Yeah, I think that's right, Phil. That's good process, right? There's a firm I was talking to in the Midlands recently, and they were saying they've stopped doing work with distance clients. They just said it's too risky. So they insist that they see the client. But again, it's a matter for you. If you're not going to see them, actual in the flesh, as it were, you must have additional checks and balances. If you do see them, how nosy are you, Philip? Anybody else? How nosy would you be? What do you do? Where do you come from? Where have you been? How long have you lived at this property? How long have you worked there, etc.? On money laundering situation, client that says I've got £50,000 saved. How many would ask show me where the money is and show me how you saved it. So Philip, everybody else, client says I've amassed £50,000. It's in a building society or bank account in my name. And you ask, how do you get it? And client says, I've saved it every month out of wages. I put, I don't know, £1,000 aside. How many people would say, right, I want to see wage slips and I want to see your bank statements showing for the last 50 months £1,000 a month going in? Or how many people would say, well, I've got to risk assess this client. I've acted for this client on a number of previous occasions. I know that he is in a well-paid job. Therefore, it isn't necessary for me to see every payment that's gone into this savings account. I'm going to ask to see the current bank statement, and I'm going to ask him if he'll produce a bank statement for me in, I don't know, January 2024. So we've got a snapshot of what's going into that account. If, on the other hand, the client was new to us, if the client was working or not working, and therefore it would be highly unusual or irregular for he or she to have £1,000 each and every month available to go into savings, then you might want to undertake a greater investigation. What would be the position, everybody, if the client said, well, no, I haven't got £50,000, but I've got a relative and he or she's gifted it to me? Would you want to have evidence from whoever's made the gift to confirm the position? Interesting, would you want to see how that person got the cash? So, great Aunt Hilda or whatever has gifted me £50,000 last week. Fine. Great Aunt Hilda, will you confirm that this is the case? Great Aunt Hilda, where did you get the £50,000 from? Ah, well, I got it from an inheritance. Well, all right, can I see how you got that inheritance? How far do we have to go, does everybody think? Well, again, what would a reasonable conveyancer do in these circumstances? It seems to me is the test, okay? But again, important that we've got systems and processes and we're applying them, okay? Firm-wide risk assessments, individual file and client risk assessments need to be undertaken, okay? So as far as client matter risk assessments are concerned, it's an assessment of client, and therefore you've got to know your client. And as Philip is saying, seeing the client, asking the client questions, getting reasonable answers to those questions, important. If you've got something that's unusual, then enhanced due diligence would be appropriate, wouldn't it, with regard to money laundering? So, hey, let's have someone else have a look at this, or let's get some more proof, or let's satisfy ourselves that what we're being told or the information that we're being provided with is accurate. Okay, firm-wide risk assessments. So this is when you're onboarding clients and taking on work, demonstrating consideration of all risk factors, including clients, geographic issues, product services provided, transaction and delivery channels, and considering all relevant sources, including the law society's sector risk assessments. So do we do all of that? And again, just, sorry to be the purveyor of bad news, it's not just a case of paying lip service to all of this, it's actually doing it and having evidence that it's been done. And with regard to this and this idea of knowledge, it's important that you as fee earners have that, or have and carry that knowledge. It's also important that your team does. So support staff, secretaries, new recruits, paralegals, etc., all need to be aware if they're having current contact, they've got awareness of everything that we do. Okay, there should be a tailored firm-wide risk assessment proportionate to the firm, and again, excuse me, a need for that to be kept under review. Record keeping a copy of documents and information obtained to satisfy the requirements of the Law Society and the AML requirements, and make sure that there are accurate and comprehensive records of decision making and reasoning. In other words, can you show your workings out, put simply? So where we've risk assessed the client in our case management system or on our file, is there evidence of our working through that assessment and the decision that's been made? Where there isn't evidence as to the decision-making process, that generates the potential for exposure and vulnerability. So please, please, please be careful. If you want more information on that, let me know. If you would like someone to come along to a future event and to talk to you about this sort of these compliance issues, happy to do that. I and Stewart Title have lots and lots of contacts that sort of deal with compliance issues day in, day out. So again, if anyone would like that, happy to organise that. As I say, there's some very enlightened people out there that can provide assistance and guidance. Okay, next thing I want to talk about is avoiding negligence claims. And again, I'm in the fortunate or unfortunate position that insurers will send me details of claims, details of what they're envisaging with regard to risk in 2025. And guess what? Some of the old favourites are still out there. Seller identity fraud, an issue. Poor communication with clients, an issue. So sending a retainer, sending a report on title, sending an advice to the client about an issue during the conveyancing process. If you're doing any of those things, are you sure that the client has received the communication? Are you sure that the client has read and understood the communication? Why not ask the client to confirm? So let's assume I'm your client. Let's assume you've given me some advice about how a beneficial interest should be held in connection with a property. And I don't want to do what you're suggesting you do or what would be reasonable and logical. I want to do something else. In those circumstances, you need to make sure that you've protected yourself. So I would expect an email to go to the imaginary me saying, we've discussed this issue. I've explained to you what would be appropriate given your circumstances. You've instructed me that you don't want to do that. You want to do something else. The risk associated with what you're asking me to do is X, Y, and Z. I am prepared to do as I'm being instructed, but I need to point out to the risks associated with what I'm being instructed to do. I would want the client to acknowledge receipt of an email of that nature and to confirm that they've read and understood its content. If I was, like Philip was saying, calling the client in to discuss this issue, I would probably want where the client is wanting me to do something that's contrary to logic, contrary to appropriate legal advice. I'd want my client to sign a letter of waiver to confirm, what is being proposed, what's being done, is inconsistent with my advice. I was talking to a firm just recently who said in a situation like that, they just wouldn't act. Now, again, I can understand why, because, if something goes wrong with regard to the advice or what is being proposed, and the client sustains loss as a consequence, the likelihood is that the client's going to start pointing the finger at you. And the point there is, unless you've got sufficient evidence to counterpunch what they're saying, you've got a problem on your hands. And again, touching on what Philip and I were saying a little earlier, if we're not charging much for the work that we do, are we going to keep a full and detailed record of every conversation we have with our clients? Probably not. The point I'm making is that there are certain conversations which are so potentially dangerous from your perspective and from a claims perspective that you need to do a belt and braces job. So again, emailing the client after a meeting, this is what we've discussed, this is what I advised, this is what you've instructed me to do. Making a full and detailed note of the attendance, sending it to the client to confirm, to ask the client to confirm this is a true record of what was discussed and what was advised. Again, these things are sensible. Follow-up meeting with a letter. I think that's wise, Philip, particularly in the context that I've just mentioned. The other point with regard to avoiding negligence claims, we're all brilliant at telling clients what we're going to do. I was just looking at some Northern Irish firms' website this morning and looking at their conveyancing teams and the conveyancing process, etc. Really interesting, okay, really good, to be honest. But the thing that worries me is that a lot of firms are happy to explain process, happy to explain their role and expertise, but when you look at it, there's a gap. And the gap is a failure to tell the client where there's third-party involvement, and also a failure to tell client what's not going to be done during the conveyancing process. Now, I get it. We're trying to sell our services. We're trying to promote our work. We're trying to attract clients. We don't want this idiot telling us that what we should be saying is, hey, you do need to realize that there are some potential pitfalls with regard to the conveyancing process. We don't want to scare clients. Well, I'm not saying we scare clients. I'm saying we just set realistic client expectation. So question, when was the last time that you looked at your retainer or engagement letter, or you looked at your report that you send to the client when due diligence is complete? When was the last time you sent it, or read it rather? When was it last reviewed? Rather than sending one report to the client when due diligence is completed, do you provide interim reports as the transaction progresses? Do you provide in the retainer an overview of the conveyancing process in your role and the documentation the client could well encounter during the conveyancing process? Do we do all of these things? I think they're important. Avoiding negligence claims. How about this? Insurers saying staff welfare, staff health is important. If staff are stressed, hey, there's a thing. If they're overworked, there's another thing. Do we monitor and manage to make sure that those issues are not impacting on work and impacting on claims or potential claims? So that goes for supervision, it goes for sort of file management, it goes for workload management. And again, just making sure that members of the team are not overloaded, making sure that work is allocated to appropriately experienced members of staff. So we're going back to that onboarding point and risk assessing files. If you've got a complex transaction, perhaps rural property with a significant amount of land attached and various buildings attached, do you want one of your relatively inexperienced members of staff that have always dealt with sort of semi-detached, detached properties, flats and apartments in Belfast handling that transaction? Watch out for resi transactions that aren't really resi transactions, sort of buy-to-let acquisitions, quasi-commercial property, and this sort of thing. Interesting question, again, arose early this week. Does anyone deal with online auctions? Anyone acting for a seller or buyer with regard to an online auction at the moment? Or has anyone acted for such a person? Again, they throw up all sorts of additional problems. Problem number one, when you're acting for a buyer, who is the buyer? Are you acting in a situation where you have a nominee that's bidding on an online auction, but that there are others that are investors? Well, in that case, who the client is. Philip saying refuse to act for a buyer in one. Yeah, well, I can understand, Philip, because there's all manner of potential risk. Interesting, there's also quite a lot of risk from a seller's perspective. If you look at an online auctioneer's terms and conditions and the contractual terms and conditions, in essence, what the auctioneer is saying is, I'm not liable for any form of misdescription or misrepresentation. So anything I say in my auction pack, sales material, etc., you can't rely on. And what that does is potentially throw liability, or should throw the potential for liability, back against the seller. So be careful. Online auctions, like face-to-face auctions, generally speaking, have their own forms of conditions of sale. And some of the online auction houses' online auction conditions for sale are radically different to what you'd see in a face-to-face auction. So again, caution needs to be exercised and care taken. Okay, other issues with regard to avoiding negligence claims. Acting for buyers, buying off plan. Anyone done that? I tell you where was a hotbed of problems with regard to that type of transaction. Liverpool. Don't know if you're aware of this, but you were getting developers that were buying sites, brownfield sites predominantly, getting planning to build tower blocks and then selling off plan flats and apartments. And there's been a whole raft of litigation where schemes have failed, developers gone bust, and buyers, the investors, have sort of lost deposits, etc. Loads of them. And so one insurer in particular is still dealing with a lot of claims in that area and saying this is still an area of concern. So, the idea with buying off plan like that is the buyer's not paying a deposit to be held by the developer pending completion, but is paying a deposit. And that deposit, those funds are immediately being used for construction and construction costs. And where the developer builder can't build out or becomes insolvent, the deposits are lost and the buyer client's left high and dry. So again, an area of claim. Failing to advise on clients about search results. It's not enough just simply give a client a copy of a search and say, read it. You're expected to extract from the search any issues or any adverse entries that would be materially adverse to the interest of the client and disclose their existence. Then what you're required to do is say to the client, look, I've identified risk or an issue here. There are steps or measures that you could take, or I could take if instructed, to deal with those measures or those issues or risks. What do you want to do? Where the client says, I'm just happy to proceed, notwithstanding, thanks for telling me about it, we go back to that problem I mentioned earlier about getting client to confirm they understand, they've read, understand, and appreciate the matter and happy to proceed, notwithstanding risk. Where the client says, I'm going to undertake my own investigations relating to risk, so say it's contaminated land, I'm going to get a further report from a consultant relating to land contamination concerning risks and issues. In your report on title, you should be saying to the client, there was an issue, courtesy of an environmental search and report. You advised me that you were going to deal with the matter yourself. You advised that you'd be instructing a contamination expert to give you advice relating to contamination risk. I haven't heard anything further from you, but I've assumed you've done this and you're happy to proceed. Where the client says to you, I want you to carry out further investigations or to instruct someone on my behalf to investigate, etc. Again, be careful. A, are you getting paid to do that additional work? B, are you simply acting as a mailbox and the client understands that you won't be giving any advice, views, or opinions on whatever information is revealed or obtained on the client's behalf? Okay, so avoiding negligence claims. Anyone wants to see a newsletter produced by an insurance broker on claims relevant to Northern Ireland, let me know and I'll happily send that across to you. The next thing I want to talk about is this case called Dixon against Sharkey. Don't know, have you seen it, anybody? Yeah, Philip, just drop me a note by email and I'll send it across to you. Yeah, anyone seen this case? Really interesting case. I'm just going to pull it up because I took a photograph of the facts of the case. It was an appeal from a county court order. And there was an argument about the beneficial interest in a residential property. You had a situation where parties lived together, basically as husband and wife, never married, but had children. They had built a house on the land that was owned by the plaintiff. And the deal was that the property was to be transferred to them both as joint tenants. But the plan was always that girlfriend, defendant rather, was going to sell her house and put the proceeds of sale into development, completing building works, renovations, alterations, etc., of the new property. Okay, that was the deal. However, there was an issue, and the issue, there was a boundary problem with regard to the lady's house that meant she couldn't sell it and never sold it. The rental income that she derived from a property which she was unable to sell was used by the couple for everyday living expenses, etc. Yeah, Philip, I will send the judgment to you and anyone else that would like to see it. At the county court held that there was a beneficial interest that was divided equally between plaintiff and defendant. So we go on appeal, and on appeal the position is no, that's not the case. Now, the reason I mention this is there's a number of points that I want to discuss concerning beneficial ownership. Number one, if you're acting for partners, married couples, buy-to-let investors that are collectively buying a residential property, for example, there's no such thing as a collective client. Excuse me, the clients are individuals with different attitudes to risk, different levels of understanding, etc., etc. They therefore have to be treated as such. How many people attending today would, in a situation where they're acting on behalf of these two individuals or persons in similar situations, would ask them to complete questionnaires confirming their status, confirming contributions in connection with the purchase of the property, current contributions, etc., future contributions relating to the property too. How many people would ask about previous relationships, children from previous relationships, etc., etc.? Again, important that those questions are asked. Next point, can you act for two parties? Answer yes, as long as there is a common interest and as long as there is not a conflict of interest. If you have a situation where there is some form of deal, so you buy the property, I'll sell a property that I own, and I'll plough that money into investment improvement of the property that we're buying together, or anything like that, you need to be aware of it, because it may be that the beneficial interest in the property will be held in one way on acquisition, but it may be necessary for that to be varied when other property is sold and funds from that utilised with regard to whatever purpose was agreed between the parties. Where the clients have uncommon interests, no common purpose, or differing interests, interesting question, can you still act? I think the answer to that question is yes, you can, as long as the clients go away and come back and have a common purpose. Where they don't, I think you can't act. You'd have to say, I can't act for you as collective clients where your instructions are inconsistent with one another, or where there's a conflict of interest as between you both. In those circumstances, I can't act for you as a collective. The next point with regard to beneficial ownership is to advise clients of the importance of keeping documentation under review after acquisition. So it's important that the commencing documentation deal with how the beneficial interest is to be held now, but there's evidence as to what is agreed with regard to the future, or that the documentation is drafted as such to give effect to what is to occur in the future. This sort of thing needs careful addressing. And again, where you're closing your file in connection with a transaction, I would remind the clients, you've bought the property, the beneficial interest is currently held on this basis for these reasons. Be aware that if those reasons alter, if the beneficial interests alter, then documentation should alter as well. So the reason I mention this is you could have a situation where clients acquire a property, equal contributions. Mr. receives a large redundancy payment and spends or blows the lot on home improvements, then surely a 50-50 split with regard to the beneficial interest would not be appropriate. And the client should be aware of the fact that it may be appropriate for the beneficial interest to be altered as a consequence. Whether the client does alter it is a matter of debate and conjecture, but at least if the client understands that, then it's down to the client as to what they want to do. Important legal points with regard to beneficial ownership. A, the courts will normally give effect to documentation. So where clients are contributing 80-20, but title reveals 50-50 split, invariably the courts will give effect to that 50-50 split unless there are exceptional circumstances that would entitle the court to make an alternative view. The most common example of exceptional circumstances would be in circumstances where parties are unrepresented. Next thing with regard to beneficial ownership, be careful to make sure that clients who have a beneficial ownership divided between them are aware that an exchange of emails could be sufficient to transfer the beneficial ownership. There was a case last year involving this very point. Parties exchanging emails and the judge turning around and saying, well, that exchange of emails constitutes a transfer of the beneficial interest. I'm quite sure in my mind that that was not what was intended by the parties, but due to the relevant law applying, that's what the court decided had occurred. Okay, anyone got any burning topics that they would like to explore today? If you don't, there's some other things I'd like to talk about. We're talking about Stewart title a little earlier and title indemnity insurance a little earlier. Two or three things. Firstly, and Robert, John, and Liz, you can help me if you can. It's important that conveyancers understand and appreciate, solicitors understand and appreciate compliance issues with regard to defective title insurance. So again, I'm sure John and Elizabeth, and indeed Robert and Ted and the team, can provide you with guidance as to what you need to do with regard to things like demands and needs statements, awareness of product, awareness of limitations relating to product and these things, point one. Point two, where you're taking out defective title insurance, do you explain to clients the duties and obligations that the client owes to the insurer? And do you explain to the client the fact that those duties and obligations are permanent and ongoing, and non-compliance could lead to invalidation of policy of insurance? Do you explain to clients? Hi, John. Yeah, you've got your hand up. Yeah, fire away, my friend, if you can.
Yeah. Just for your information about that, a couple of sources.
Yeah.
UK Finance Handbook has got a section on what to do as far as title indemnity policies are concerned.
Yeah.
That's the first thing. The second thing is law societies in Northern Ireland, Scotland, and England and Wales have got incidental financial business rules.
Yes.
If you look at the incidental financial business rules, you will find that they are stated there,
All right. Thank you.
as in what the
Yeah.
relationship between the lawyer and the insurance company is,
Yeah.
and what the obligations of the lawyer is to his client, and what the obligations to the client to the insurance company are.
Yeah.
There's also a thing called an IPID, an insurance product information document that you get with every policy of insurance, whether it's car insurance or whatever.
All
That
right.
gives a summary of the policy itself.
Mm-hmm.
And whilst it's not a substitute for the policy itself, it's a good way of explaining the terms of the policy to the client. It's a very summary, but
All right.
that's
Excellent.
probably a starting point. And lastly,
Hmm.
if anybody wants to explore that in more detail, we have got a seminar that we do for clients and
Right.
for firms,
Yeah.
basically covering that very point. So I don't know if that's any help to you, Ian,
It
but
is.
that's
Well, of course it is. So, John, on that point, then, is that the sort of virtual training session, or do you go out, or how does that work?
we'd rather go out, to be honest.
Right.
We'd
Yeah.
rather
Yeah.
see
Yeah.
people face to face, because
Mhm.
it's quite dry, and we try to make it more interesting, and it doesn't
Can't
come
believe
across
that. Yeah.
too well on Teams. So
Can't
if
believe it.
we'd rather, if if you had enough people, if you get enough people together in Northern
Right.
Ireland, 2 or 3 firms,
Yeah.
we could, either myself or Liz or both of us could go and do that.
Brilliant.
So
All right.
that
Well,
may be an idea.
yeah, let's work on that, John. Thank you very much indeed. That's absolutely brilliant. Very good. Well, look, that was fantastic. Thank you, John. What I want to do, because time is creeping up on us, just to make sure that you're aware of some of the products that Stewart Title has available. The point I made in my introduction, I think, is important and worth repeating. That where you come across something that's weird and wonderful, worth talking to John or Liz or the team in London to see if there is a product already in existence. And if not, I hope I'm not speaking out of turn, but I'm sure that Stewart Title would have a look to see if it's possible to create a bespoke policy. And as I mentioned earlier, in addition to resi policies, there are commercial policies as well, standalone policies, unique policies, and a raft of sort of standard products that you can buy off the shelf, as it were. What I would like to do now, I think, is just see if anyone's got any other comments or any other issues. If anyone wants details of cases, etc., I'm just going to show you a couple of slides. Robert Kelly, Stewart Titles, email address, telephone number on there. And this is a slide that I wanted. If you have any questions or queries or topics for next time, drop me a note by email at info@iqlegaltraining.com. Remember, these events are your events. They're sponsored by Stewart Title. But at the end of the day, it's down to you. And Stewart Title are very kind in that they say, look, if there are speakers that want to come along, if there are providers of other product that want to come along, get them along. Anything we can do to help the legal profession, conveyancers, solicitors, particularly in Northern Ireland, delighted to do so. And again, John and Liz's invitation to come out and do some training for you with regard to compliance issues. You've heard that from the horse's mouth this afternoon. On my behalf and on behalf of Stewart Title, what I'd like to do, I think, is to thank you all very much indeed for giving up of your time today. Drop me a note if you have any questions or queries. What I'm really interested in, topics for next time. Thank you very much, Philip. Thank you, everybody else. John, really appreciate your time. Elizabeth, Robert, and the team at Stewart Title, thank you for inviting me along. Planning law, says Philip. Philip, I'm making a note of that, and let's see if we can include that as a topic for next time. But in the meantime, thank you all very much indeed for coming along today. I don't think we'll be speaking again before Christmas. Given that, I hope you have a lovely time, manage to get some time off, and that the weather stays kind. Thanks very much, everyone. Love the emoji, Philip. Take care, everyone. Stay safe. Speak soon. Thank you. Bye-bye.